What happens when a company enters winding up and a critical legal dispute suddenly emerges? What if creditors disagree with the liquidator? What if there is uncertainty regarding recovery of unpaid share capital? What if legal proceedings are causing chaos and stakeholders are unsure who has the authority to decide? Can the company liquidator take independent action? Can creditors directly approach the tribunal? Can the tribunal intervene and issue directions to protect stakeholders? Hidden inside the winding up framework lies a powerful provision that can influence the fate of creditors, contributories, shareholders, directors, and even the ultimate recovery available from a distressed company. That provision is Section 322 of the Companies Act 2013. Welcome to Corporate and Securities Law Compass, navigating law with clarity. Today we are discussing Section 322 of the Companies Act 2013, a highly important provision dealing with the power to apply to the tribunal for determination of questions arising during the winding up of a company. Although this provision is presently marked as yet to be notified, it remains extremely important from an academic, professional, governance examination, and conceptual perspective because it demonstrates how the legislature intended to provide judicial supervision over complex winding up disputes. To understand Section 322, we must first understand the environment in which it operates. Whenever a company enters winding up, numerous legal, financial, operational, contractual, and stakeholder disputes begin to emerge. Creditors seek repayment. Contributories seek protection of their rights. The company liquidator attempts to realize assets. Directors may face scrutiny regarding past conduct. Investors want clarity regarding residual value. Employees seek settlement of dues. Regulators may continue investigations. Litigation may remain pending. In such circumstances, difficult legal questions frequently arise. The legislature recognized that these questions cannot always be resolved solely by the liquidator. There must be a mechanism through which stakeholders can approach the tribunal for authoritative determination. That is precisely the objective behind Section 322. The legislative intent is to ensure fairness, judicial oversight, procedural certainty, and effective administration of winding up. The provision recognizes that winding up is not merely an accounting exercise. It is a legal process involving competing interests and conflicting claims. Section 322, therefore, creates a pathway to seek guidance and intervention from the tribunal. The first part of the section provides that the company liquidator, any contributory, or any creditor may apply to the tribunal for determination of any question arising during the course of winding up. This is extremely significant. Notice that the right is not restricted to the liquidator alone. Creditors also receive standing. Contributories also receive standing. This broad access mechanism strengthens stakeholder protection. The expression contributory is an important legal concept. A contributory generally refers to a person liable to contribute to the assets of the company in the event of winding up. Many students incorrectly assume that only shareholders are relevant during liquidation. In reality, contributories play a significant role within winding up proceedings. Another important phrase is any question arising in the course of winding up. The language is deliberately broad. The legislature understood that every winding up presents unique challenges. A dispute may arise regarding ownership of assets. A disagreement may arise regarding creditor claims. A question may arise regarding realization of company property. A controversy may arise regarding unpaid calls. A legal uncertainty may emerge concerning distribution of proceeds. The tribunal can be approached whenever such issues require determination. The second important feature of Section 322 relates to the powers of the tribunal concerning enforcement of calls, staying of proceedings, and other matters connected with winding up. The concept of a call becomes highly relevant during liquidation. If unpaid amounts remain due on shares, the company may seek recovery from members. Such recovery may become necessary to satisfy creditor claims. Where disputes arise regarding these calls, tribunal intervention may become necessary. The provision therefore strengthens the liquidation machinery. The law seeks to maximize fairness while preserving the value of the company's estate. Another important component concerns stay of proceedings. Imagine multiple legal proceedings being initiated simultaneously across different jurisdictions. One creditor files a recovery suit, another begins execution proceedings, another seeks attachment of assets. Such fragmented actions may adversely affect orderly liquidation. The tribunal may therefore be requested to exercise powers necessary to ensure efficient administration. The provision further allows the company liquidator, creditor, or contributory to seek an order setting aside attachment, distress, or execution imposed against company assets after commencement of winding up. This aspect is extremely important from a creditor equality perspective. Corporate insolvency and liquidation laws generally seek to prevent a race among creditors. The law discourages a situation where one aggressive creditor captures assets at the expense of others. Instead, assets should generally be administered through an orderly legal framework. Section 322 supports this principle. The governance philosophy behind the provision is transparency, fairness, and equitable treatment. A distressed company often possesses limited resources. Those resources must be managed carefully. The tribunal acts as a supervisory authority to ensure justice among competing stakeholders. The section further provides that if the tribunal is satisfied that determination of the question, exercise of power, or issuance of the requested order would be just and fair, it may grant relief on such terms and conditions as it considers appropriate. The phrase just and fair is particularly important. It gives flexibility to the tribunal. Corporate disputes are rarely identical. Rigid rules cannot address every factual situation. The tribunal therefore receives discretion to fashion suitable remedies. This reflects a broader principle of company law jurisprudence. Equity often supplements strict legal rules during liquidation proceedings. Another practical aspect concerns communication with the registrar. Where proceedings are stayed under the section, a copy of the order must be forwarded to the registrar for appropriate recording. This promotes transparency and regulatory visibility. From a secretarial compliance perspective, maintenance of proper records becomes essential. Professionals involved in liquidation should ensure that all tribunal orders are preserved, monitored, and appropriately communicated. Although Section 322 does not prescribe a separate shareholder approval process, board approval process, explanatory statement requirement, ordinary resolution requirement, or special resolution requirement, understanding its relationship with winding up proceedings is important. The provision operates after winding up proceedings have commenced and functions as a judicial remedy mechanism. From an examination perspective, students frequently confuse Section 322 with ordinary corporate governance provisions. The section is not concerned with routine management. It is concerned with dispute resolution and judicial intervention during winding up. A practical case study can illustrate its significance. Suppose a company enters winding up. After commencement of winding up, A creditor obtains attachment over a valuable factory belonging to the company. Other creditors object and argue that the attachment undermines equal treatment. The company liquidator approaches the tribunal seeking appropriate relief. Section 322 provides the statutory basis for such intervention. Consider another example. A dispute arises regarding whether certain shareholders are liable for unpaid share capital. The liquidator believes recovery should be initiated. The concerned members dispute liability. The tribunal may be requested to determine the question. Such determinations can materially affect creditor recoveries. Corporate governance professionals should appreciate that liquidation does not eliminate legal complexity. In many situations, disputes become even more intense after winding up begins. That is why judicial oversight remains essential. For company secretaries, the provision highlights the importance of maintaining accurate records throughout the life cycle of the company. Incomplete records often become major obstacles during liquidation proceedings. For chartered accountants, the provision demonstrates the importance of financial evidence and proper asset documentation. For cost accountants, operational records may become relevant in valuation and recovery proceedings. For advocates, Section 322 provides a procedural gateway for seeking tribunal directions. For creditors, it offers an avenue to protect recovery rights. For contributories, it offers protection against arbitrary action. For investors, it reinforces confidence that liquidation is subject to judicial supervision. The provision also connects conceptually with the broader winding up framework under the Companies Act 2013, including provisions dealing with company liquidators, contributories, creditor rights, realization of assets, settlement of claims, and dissolution of companies. From a litigation risk perspective, failure to seek timely tribunal directions may result in avoidable disputes, inconsistent actions, stakeholder challenges, and delays in liquidation. A prudent professional should therefore identify unresolved questions at an early stage and consider whether tribunal intervention may be appropriate. One hidden practical insight is that uncertainty itself can destroy value. Delays reduce recoveries, litigation increases costs, stakeholder conflict erodes confidence. Section 322 was designed to reduce such uncertainty by providing a formal mechanism for obtaining authoritative judicial guidance. As we conclude, Section 322 represents an important pillar of the winding up framework under the Companies Act 2013. Even though the provision is presently yet to be notified, it provides valuable insight into the legislative philosophy governing liquidation. It recognizes that winding up inevitably generates disputes, competing interests, and legal uncertainty. Rather than leaving these matters unresolved, the law empowers the tribunal to determine questions, supervise the process, protect stakeholders, and ensure that justice and fairness prevail. For company secretaries, chartered accountants, cost accountants, advocates, directors, creditors, investors, and governance professionals, Section 322 demonstrates a timeless principle of corporate law. When uncertainty threatens the orderly administration of a company in liquidation, judicial oversight becomes the foundation of fairness, accountability, stakeholder protection, and confidence in the corporate legal system. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SAY-BEE, Prohibition of Insider Trading Regulations, 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.